One of the reasons, of course, we're here tonight, George, is to discuss the third-party claim. And here is a user-friendly definition of a workers' compensation third-party claim. It's a claim for when a worker is injured on the job through fault by someone other than the employer. And again, I know that's very stripped down and very bare, but essentially, George, we're talking about if there's a reason that someone has been injured on the job and it's not because of an employer or someone under his control, then the employee the injured worker might find a way to get around the system. And now we're starting to talk about the kind of personal injury dollars, the kind of pain and suffering dollars, which would make him whole, which the workers' compensation was never designed to do.
Correct. Those are the cases that really can make a big difference in a person's life, especially a person who's catastrophically injured. And there are many instances where a person will have a work injury and it will be caused by a third party. Caused in a variety of ways. Like you said, there could be a person working in a context where they have a product that was defectively designed or defectively manufactured, failed to have a guard on it, was not properly...
A lathe or a jigsaw or a computer that electrocutes you.
The sky's the limit. There are any number of products that could be defective out there that would cause a work injury, and you have the employer who's responsible for workers' comp benefits, but then you have that third party, that manufacturer or the seller or the distributor. There's a whole lot of people in the chain of distribution of a product under Pennsylvania law that could be responsible. For example, in a product liability case, the standard of proof is what's called Section 402A of the Restatement of Torts, and that says a product must be manufactured with every element necessary to make it safe for its intended use. If it's not provided with those elements, then the manufacturer, distributor, seller, whoever may be responsible, and then you can get into a jury trial. You could ask for pain and suffering, past pain and suffering, future pain and suffering, future medical expenses, all things that won't be covered by comp. There's a drawback, there's a catch, that the workers' comp carrier, the insurance company, has a subrogation right. And what that big word means is that if the workers' comp carrier, if Melissa's client has been paying out wages every week to this person, paying their medical bills, it could be hundreds of thousands of dollars, that if you go in front of that jury and the jury awards you $3, $4, $5 million, whatever the case may be. A
chunk of that's got to go back to Melissa's client.
Right, and I've had many of those cases in my career where I'll go in and get a big award for a person who was injured at work, and then we have to work something out on the lien.